To get a deeper understanding of governments, policies, and societal issues, we are here to present about how laws are important for maintaining such regulation of behavior in an individual. Before getting into the subject, the famous philosopher named Thomas Hobbes, in his book Leviathan, discussed that in the state of nature, man always revolt against the weaker personality. Everywhere, man is at conflict with one another. He tries to motivate to escape this chaotic nature of state by creating a social contract. Thus, through the social contract, he was able to prevent the loss of life and emphasize a strong government and social order, which resulted due to the lack of security and protection. So, a topic of discussion of why laws are significant is mainly to resolve the conflicts, to create a framework of interaction between the society and the governmental institutions, and further to eliminate or prevent the chaos, and finally to create a fair and just environment. Welcome back to another episode of laws related information. Today we are going to discuss about the protection and promotion of laws related to the human rights of young people. Yes, today's topic of discussion was juvenile justice laws. Latin word of juvenile describes it as a people who were young. So, a juvenile can be considered, as per the Section 2 of 1986 of Juvenile Justice Act, as a young person, and a young boy below 16 years of age, whereas a girl is considered as a juvenile if she attains the age of 18 years. The juvenile justice law reflects one of the primary problem that a society in which we live should be in a position to identify that is, when a person is considered to be a juvenile under this act, this majorly reflects the social neglect. So the law should also be in protecting the rights of children. The juveniles come under two categories. First one is the child in conflict with the law, and the second is child who is in need for care and protection. Before moving on to the core problem that arises in regard to the law relating to juvenile justice system, we should first consider the necessity of juvenile justice. As per this law, it protects, as mentioned earlier, it protects the human rights of the young people. And next, it holds the accountability for their actions. This law is unanswerable for young people to prosper or to nurture in a good direction with a good virtues, and thirdly, to promote or to create an environment for rehabilitation and to prevent the delinquent behavior through education, vocational training, social and economic basic life skills, etc. And finally, to make the youth a fair hearing of their legal rights. The juvenile system in India is attracting increasing interest due to the fact that in the past few decades there has been an unprecedented increase in the crimes by children who were below the age of 18 years. The most infamous was the 2012 Nirbhaya gang rape case in the New Delhi. This serves as a warning to the Indian society, as children are the paragon of development and the future of the nation. So, a healthy and a safe environment must be provided for utmost nurture of their character. The core problem of a juvenile justice system in India seems to be that it does not have a strong deterrent effect on antisocial behavior of the youth. Further, the courts allow minor to be tried as an adult. So, we should re-examine the laws related to juveniles in India. The question comes here: why do juveniles commit crime? And what causes a juvenile delinquency? Turning to criminals is often of other issues in the life of a minor. It is because The court tries to approach criminal acts differently with underage offenders than with adults. Understanding the causes of juvenile delinquency is an integral part of preventing a young person from involvement in inappropriate, harmful, and illegal conduct. The most common reasons for a minor to turn to juvenile delinquency include individual risk factors, that is, impulsive behavior, uncontrolled aggression, and an inability to delay gratification. This makes the juvenile involvement in harmful and destructive activities. The second reason could be identified as a family risk factor, where the family include a lack of proper parental supervision or ongoing parental conflict, neglect, and abuse. Parents who demonstrate a lack of respect for the law and social norms are likely to have children who think similarly. And the third factor that come in the line are mental health issues. They're primarily a personality disorder that cannot be made in regard to child. And next, substance abuse risk factors. Juveniles are using more powerful drugs today, and the age of juveniles using drugs is also much younger. Recently, children in elementary schools are found to be using powerful illegal drugs. This motivates the young people to commit crimes to obtain money for drugs, and also involve them or engage them into destructive, harmful, and illegal activities. And finally, the most noted and the short-term and long-term harm, including in psychopathology in later life, is related to child sexual abuse. They include depression. The effects include depression, post-traumatic stress disorder, there are etc. are instilled in them. According to National Institute of Judicial Study, abused and neglected children were 11 times more likely to be arrested for criminal behavior. The Juvenile Justice provides a Juvenile Justice, Care and Protection of Children Act 2000 as a framework for a legal juvenile justice in India. It provides special approach towards the prevention and the treatment of juvenile delinquency. This act aims to consolidate and amend the laws related to juveniles who were in conflict with law and the child who need of care and protection. Provide a child-friendly approach keeping their best interests in mind while dealing with them. This act sources its principles and foundations from the Constitution of India, Article 15 of E, which talks about permission of state to make special provisions for child and women, and Article 39 of E, directing the state to safeguard tender age of child from entering into the jobs unsuited for their age. Article 39 of F, also directing the state to secure the facility for the healthy development of children and to protect them against exploitation. Article 45, free and compulsory education. Article 47, a duty of the state to raise the level of nutrition and standard of living. This was replaced by the Juvenile Justice, Care and Protection Act 2015 by making many provisions of child rights fraternity. This act sought to create a universally acceptable adoption of law in India. Ministry of Women and Child Development of India is working towards bringing amendment primarily to remove courts from adoption process, to hand over it to executive magistrates, etc. How far is the Act of 2000 different from the 2015? The features of Juvenile Justice, Care and Protection of Child Act 2000 is known for the Reformatory Act that deals the child under two categories as mentioned earlier. The competent authority to deal with the child in the need of care and protection is Child Welfare Committee, with the 4 members of them, at least one should be women. A Juvenile Justice Board is a competent authority to deal with the child in conflict with the law. Further, the Act provides for the establishment of various kinds of institutions for the reception of children who were in need and care and also in conflict with the law. Observation homes are meant for temporary reception and after they has to be discharged from the child's home or special homes. The rules under this Act has come into force by an official gazette. Section 68 prescribes various areas where the rules can be applied for the better implementation of Act. The Juvenile Justice, Care and Protection of Children Act 2015 was passed by the Parliament to replace the Juvenile Delinquency Law and the Act 2000. The important features of this act are any child that found committing the crime now be sent to preliminary assessment for a period of 3 months, up from the earlier 1 month. The preliminary assessment is not a trial but to assess the child's capacity to commit the crime. The Act will allow the Juvenile Justice Board to include the psychologist and the sociologist to decide whether the juvenile criminal is under the age group of 16 to 18 years, be tried as an adult or not. A new clause on fair trial is added to look into the special needs of the children and to create a child-friendly atmosphere. Biological parents giving up the child for adoption will be given 3 months to rethink the decision instead of existing 1 month. This act introduced foster care in India. No life imprisonment or the death sentence to a juvenile is imposed, and the inquiry of the case should be completed within 4 months of the first production of child in Juvenile Justice Board, and later this can be extended for the maximum of 2 or more months by recording the reason in writing. As per the National Crime Report, NCRB reports, a startling fact was revealed by them. Of all the crimes that was committed by the juveniles, 99.3% of them were done by the boys, and 3/4 of them fall under the category of 16 to 18 years, and only 1% fall below the age group of 12 years. To put the picture at a broad scale, 85% of the apprehended were living with their parents, and 9% were their guardians, and 6% who commit the juvenile crime were homeless. So, rather than considering the juvenile crime as a heinous offense, it should also be verified that and should also be noted that it is totally a social neglect. So, to maintain the children as a symbol of development and future of nation, a safe and healthy environment must be provided for them to nurture their character. Unfortunately, due to several factors, innocent children were turned into juvenile delinquents. The delinquents go through a lot of abuse which vary in nature as physical, sexual or psychological, and create a long-lasting and profound effect on a child life. Thus, our criminal jurisprudence regarding the juvenile offenders prevention is better than cure regarding juveniles, and they must be protected from going in a wrong and the dark path. Further, our Constitution provides a safe and a separate treatment for children. The measures should be taken for the benefits of juveniles and establish a proper linkage between the state and various district governments. The problem is not with the Act but with its implementation. So, the need of an hour is to fix the systematic problems and strengthen the existing juvenile justice system. Law can never be a solution, but it can only supplement the solution. We cannot uproot this menace, but there are solutions to keep a control on the problem of juvenile delinquency, so that a state can play a constructive role in the society in protecting and the promotion of the human rights of children, and come up with reformative methods and instill in them values that socially uplifts them. Thank you. Have a nice day.